are hale and hearty. I am going to start to dictate first dictation of the day on legal matter at the speed of 100 word per minute. Get ready. Start. On applying the law expounded by this court in a series of decisions to the facts of the instant case, we find that the division bench of the High Court has dismissed the appeal preferred by the appellant state government and set aside the order passed by the learned single judge who had upheld the order passed by the competent authority terminating the services of the respondent on the ground that he was candid enough to make a disclosure in his verification form stating that he had been charge sheeted in a criminal case wherein he was later on acquitted and there was no other criminal case pending against him at the relevant time. We are, however, unable to concur with the aforesaid view. Even though the respondent had truthfully declared that he was involved in a criminal case which was decided by the trial court wide judgment 26 October 2015 on perusing the facts of the said case as noted here in above and the observations made in the judgment quite clearly, this was not a case of clean acquittal. It is evident from the facts narrated that after the charge sheet was filed, the respondent had arrived at a compromise with the complainant and filed an application under section 320 of the Code of Criminal Procedure, based on which the offense under section 341 Indian Penal Code was compounded. As for the remaining offences for which the respondent was charged, that is section 354 within bracket D of the Indian Penal Code and section 11 within bracket D/12 of the POCSO Act, they were non-compoundable and therefore the matter was taken to trial. The respondent was acquitted by the trial court primarily on account of the fact that the complainant did not support the case set up by the prosecution and the other prosecution witnesses had turned hostile. In such circumstances, the respondent's plea that he had been given a clean acquittal in the criminal case is found to be devoid of merits. This is a classic example of the situation contemplated in para 38.4 of Avatar Singh within bracket Supra, where the charges framed against the respondent herein involved moral turpitude, and though he was acquitted on the prosecution witnesses having turned hostile, but given the facts and circumstances of the case which led to his acquittal, we are of the view that the appellant state government was well within its right to exercise its discretion against the respondent and terminate his services on the ground that he was unfit for appointment in the police department. Here was a case where the complainant had re-engaged from the statement made to the police in view of the a settlement arrived at with the respondent. It is noteworthy that the incident subject matter of the criminal case had occurred on 14th February 2015 and judgment was pronounced by the trial court on 26th October 2015 In the very next year, when the appellant state government invited applications for appointment to the post of constable, respondent had submitted his application. This was the first dictation of the day. Now I am going to dictate the second dictation on legal matter at the speed of 100 words per minute. Get ready. Start. It is noted that neither the contesting respondents nor the appellants ever raised this contention at any stage of the proceedings in transfer petition number 822 of 1991. It would therefore be too late to raise such a contention when the seniority list has been finalized pursuant to the judgment of MAT Bombay Bench in transfer petition number 822 of 1991. The contention raised on behalf of the appellant that he should at least be paid the salary and allowances as paid to the assistant teachers in the higher secondary section for the time he functioned should also fail for the reason as set out herein above. The appellant, however, cannot be denied continuity of service under the Master Circular dated 29/1/1991, read with the orders of this court in Srimati Jayashree Dev Roy within bracket Datta bracket close within bracket Supra bracket close, and the order in the appellant's own case, that is CA number 3557 of 1996 dated 15/2/1996. This is a fresh cause of action which has arisen in view of his absorption on 2/1/1998 subsequent to the culmination of the earlier round of proceedings. The conduct of the authorities themselves in subjecting the appellant to screening before the screening committee, like they did for Srimati Jayashree Dev Rai within bracket Datta bracket close and others, also clearly indicates that even they wanted to treat the appellant's case on par with the case of Srimati Jayashree Dev Roy within bracket Datta and others. It is on that basis that the appellant was found fit for absorption as a primary teacher, and he was so absorbed. The only reason given in the order denying continuity for the appellant while granting continuity of the same for the others is that in the case of the appellant, this court had not directed any specific order regarding continuity of service. The appellant's right, first of all, flows from the Master Circular dated 29/1/1991, as has been rightly contended by learned counsel for the appellant. A reading of the above clearly shows that on completion of 3 months of continuous service as substitute teacher, the incumbent acquires temporary status. It is also clear that substitutes who have acquired temporary status should be screened by the screening committee and not by selection board. It is also clear that under clause 5.11, gaps which may occur in service of substitutes between two engagements should be ignored for the purpose of temporary status on completion of 4 months service, and in case of teachers on completion of 3 months service. Further, it is clear that the date of appointment should be the date on which they attained temporary status in the event they are regularly absorbed. As is clear from the dates mentioned herein below, that the appellant, having acquired temporary status on 4/3/1990 is entitled to count his service from 4/3/1990 in view of his absorption in the service as a primary teacher on 2/1/1998. The authorities are wrong in stating that in the case of the appellant, this court had not directed any specific order regarding continuity of service. This was the second dictation of the day. Now I am going to dictate the third matter on legal matter. At the speed of 100 words per minute. Get ready. Start. The Central Administrative Tribunal, Calcutta bench has recorded that the applicant had functioned as a mathematics teacher for class 11th and 12th as a stopgap measure. This issue, however, need not detain the court any longer, as at no point in the first round of proceedings the appellant made such a claim. The screening committee, having considered him pursuant to the orders of this court, has thought it fit to absorb him only as a primary teacher. The screening committee itself was pursuant to the orders of this court and based on the Master Circular of 29/1/1991, wherein the claims of the candidates like the appellant were examined. The records of his appointment as a substitute teacher admittedly show that he was only appointed as a substitute primary teacher. It is on the completion of 3 months as substitute primary teacher that he acquired temporary status, and on absorption now he became entitled to certain benefits under the circular which we have elaborated herein above. In the earlier round of proceedings culminating in the order of this court dated 15/2/1996, this issue was never raised. His claim for absorption as an assistant teacher in the higher secondary section is clearly barred by constructive res judicata. In trying this question, I believe I state the rule of the court correctly when I say that where a given matter becomes the subject of litigation in and of adjudication by a court of competent jurisdiction, the court requires the parties to that litigation to bring forward their whole case and will not, within bracket, except under special circumstances, bracket close, permit the same parties to open the same subject of litigation in respect of matter which might have been brought forward as part of the subject in contest, but which was not brought forward only because they have, from negligence, inadvertence, or even accident, omitted part of their case. The plea of res judicata applies except in special cases, not only to points upon which the courts was actually required by the parties to form an opinion and pronounce a judgment, but to every point which properly belonged to the subject of litigation and which the parties exercising reasonable diligence might have brought forward at the time. This principle, popularly known as the doctrine of constructive res judicata, based on the might and ought theory, has been recognized by this court in several judgments. It was then contended on behalf of the appellants that neither the recruitment rules of 1971 nor the seniority rules of 1982 provided for carrying forward the vacancies falling in either category. In the absence of such rules which specifically provide for carrying forward the vacancies falling in either category, no such carry forward rule could be implied either in the recruitment rules or in the seniority rules. This contention need not detain us any longer because such a contention was available to the appellants in the earlier proceedings, namely transfer application number 822 of 1991, and the same was not put in issue. Now I am going to dictate the third matter, which relates to legal matter at the speed of 100 words per minute. Get ready. Start. The appellant was appointed in 1989 only as a substitute primary teacher in the pay scale of the primary teacher, and hence merely on the basis of the claim that some stopgap classes 11th and 12th were taken, no plea for absorption as assistant teacher could be justified/made. He defended the order of absorption dated 2/1/1998 and also contended that the authorities were justified in passing the order of 28/12/1998 denying continuity of service for the period before 2/1/1998, since there was a clear distinction between the judgment of this court in the case of Srimati Jayashree Dev Rai within bracket Datta bracket close and in the case of the appellant. Drawing attention to the orders of this court in the case of Srimati Jayashree Dev Rai within bracket Datta, learned counsel contends that in the case of Srimati Jayashree Dev Rai within bracket Datta within bracket Sopra, there was a specific finding that the appellants in that case were entitled to continuity of service in accordance with para 5.1 of the Master Circular dated 29/1/1991. In the event the screening committee found them fit for absorption. Contrasting this with the judgment of this court in the appellant's case, learned counsel would contend that no such direction for granting continuity of service in the event of absorption was given in the appellant's case. Learned counsel would contend that even factually the case of the appellant was different from the case of Srimati Jayashree Dev Rai within bracket Datta, inasmuch as Srimati Jayashree Dev Rai within bracket Datta was in service on the date of absorption with while the appellant was not. This submission is seriously disputed by Ms. Uttara Babbar. Nothing much, however, turns on this last submission of the counsel for the respondents. We have considered the rival contentions and perused the records. We are of the view that the appellant's claim for absorption as assistant teacher in the higher secondary section in the pay scale of rupees 5,500 to 9,000 is not tenable. The appellant was appointed as a substitute teacher in the pay scale of a primary teacher. In fact, when he filed the first round of proceedings in OA number 209 of 1991, no plea was raised that he worked as an assistant teacher in the higher secondary section. even when he obtained interim orders from the tribunal on 3/12/1990. It was only to the effect that the services of the appellant should not be dispensed with without the leave of the court. Even before the tribunal, the argument was only about regularization. Before this court too, no claim for regularization as assistant teacher in the higher secondary section was made. The contention now raised in the present round of proceedings within bracket OA number 978 of 1998 bracket close for absorption as assistant teacher in the higher secondary section is strongly refuted by the respondents by pointing out that his engagement as a substitute teacher was only in the pay scale of rupees 1200 to 2040, which was the scale for the primary teacher. They contend that his claim that he was allowed to take classes for 11th and 12th is unfounded. Now I am going to dictate the next dictation at the speed of 100 word per minute. Get ready. Start. We have heard Miss Uttara Babbar, Learned Counsel for the Appellant, and Mr. Nachketa Joshi, Learned Counsel for the Union of India. Both the Learned Counsel have painstakingly taken us through the records of the case and presented their respective points of view very ably. Miss Uttara Babbar, Learned Counsel for the Appellant, contends that under the Master Circular dated 29/1/1991, Clause 4.3, 5.1 and 6 would apply to the case of the appellant. According to her, on completion of 3 months continuous service, the appellant acquired the temporary status under Clause 4.3 that under Clause 5, substitutes who have acquired temporary status were to be screened by a screening committee and not by selection boards for the purpose of absorption, and under Clause 6, the date of appointment of a substitute to be recorded in the service book against the column date of appointment close should be the date on which the substitute attains a temporary status after continuous service of 3 months, if the same is followed by his/her regular absorption. According to the Learned Counsel, only for those who do not acquire temporary status and who are regularly appointed, the date of appointment would be the date when they are absorbed. According to the Learned Counsel, the appellant having completed 3 months of continuous service as a substitute teacher is entitled to reckon his date of appointment as 4/3/1990 within bracket on completion of 3 months bracket close, since he now stands duly absorbed by the order of 2/1/1998. According to the Learned Counsel, the appellant ought to have been absorbed as assistant teacher since he worked as a substitute assistant teacher and taught classes 11th and 12th. Her further alternative case is if he has to be only considered as absorbed under the category of primary teacher, then he should be entitled to the benefit under the Master Circular dated 29/1/1991 and should be entitled to reckon his service under Clause 6 of the said circular from 4/3/1990. Learned Counsel further contends that even the authorities so understood the orders of this court, and it is for that reason that they subjected the appellant also to a screening before the screening committee before the absorption on 2/1/1998. Learned Counsel contends that having done so, there was no plausible reason to discriminate the case of the appellant when it came to the grant of relief regarding continuity of service on the ground that this court had not made any specific order regarding continuity of service. Learned Counsel contends that the grant of age bar relaxation can only be understood as a grant of additional relief, and this cannot be read to mean that there was denial of the relief of continuity of service if the appellants were found entitled for absorption, which they ultimately were found be entitled to. Mr. Nachketa Joshi, Learned Counsel for the Union of India, vehemently opposed the above submissions. Learned Counsel, defending the orders of courts below, would submit that the claim for absorption was totally unjustified. This was the last dictation of the day. Thank you. Good night.